And National Trial Attorney Michael Jaafar. Michael, to you first. This 911 call, we talked about it last week. The judge said, no, you can't play the call unless you find the woman. And if you find the woman's voice and bring her in, fine, we'll talk about it. But at this point, you're not playing the call. Is that something that could pick up some traction?
Not really. It's not enough. You know, I took a lot of flack from my colleagues when the prosecution rested their case, when the state rested their case, because I predicted she'd get convicted before the defense put on her case. I said, there's enough. They've met their burden. And I can't see how the defense is going to overcome that burden. So that 911 call would not have, in my opinion, would not have made a difference, because what's going to happen? Think about it. The detective testified that there were no prior incidents between these two. She had never called the police for help with this situation. She had not, this is the first they've ever heard of her and her situation with the victim, right? And so what would that 911 call could possibly have said? It would have been hearsay. It would have been somebody other than the defendant, the victim himself. So I don't see how it would have made a difference, and definitely not enough to overturn this. Look, the judge clearly did not agree with the jury. The jury made their decision, but the judge clearly did not agree with their decision. Because you saw a woman walk out. When I saw her walk out with her kids, I thought, wow, I was wrong. She got acquitted. And then I read more. I was like, well, she actually got convicted, and she's walking out on a sunny day. I've never seen this in 17 years of practice. I'm sure it has happened. It happens in situations that are very unique, but not like this. I've never seen that.